Good evening, everyone. For anyone I have not had the pleasure to meet, I'm Jutta Brunet. I'm the Dean of the Faculty of Law, and my fellow Dean of the Rotman School, Susan Christofferson, is here with me, and we're delighted to be welcoming you to this very special evening. Thank you all for joining us for tonight's John A. Tory Lecture, which is a truly exciting first of many, but a first that is worth marking. I'd like to begin tonight's event by acknowledging the unique connection and the unique and enduring relationship that exists between Indigenous peoples, their traditional territories, and the university. So we wish to acknowledge this land on which the University of Toronto operates for thousands of years. This has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. And today this meeting place is still home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to learn, work, teach, and build community together in a good way on this land. In 2023, Susan Christofferson and I were thrilled to announce a very generous gift from the family of the late John A. Tory. This wonderful gift honored John's name and legacy while marking the largest endowment supporting scholarships and bursaries for JD MBA students at the university. The gift established the John A. Tory JD MBA Scholars, an honor which so far has been awarded to a total of 6 JD MBA students, as well as this new lecture series in tax law, which, as I've alluded, beginning today will be held annually. I am really delighted to share that John H. Tory is here with us tonight representing the family. The Tory family chose to honor their father, a remarkable Canadian businessman and lawyer, by advancing the 2 pillars that were at the core of his professional life. And their gift supports our students in pursuing their dreams to become leaders in business and law, following in John's impressive footsteps. John, it's because of you and your family's incredible support that we're here tonight, and I would invite everybody to join us in applause thanking the Tory family. So we're here tonight to celebrate the inaugural John A. Tory Lecture, and without much further ado, I would like to introduce the 2 speakers, or a speaker and a moderator, who will be leading us through tonight's discussions. The JD MBA program and this event are designed specifically for those who are interested in the many ways the law intersects with the business world, and I really can't think of 2 people better suited to giving us a taste of that. Moderating the questions tonight will be the Faculty of Law's Osler Chair in Business Law, Professor Benjamin Alarie. Professor Alarie is a recognized leader in applying AI to tax law. He is also the co-founder and CEO of BlueJay, a leading AI-powered platform for tax research, known, I have learned fondly, as TaxGPT. And our keynote speaker tonight, the Honourable Frank Iacobucci. And probably would be fair to say that he does not need any introduction. The other truth is that he deserves an introduction that is probably longer than we would be wanting to spend time here tonight. So I know that Frank is very generously minded, and he will indulge me for being very, very brief. But I do want to say that he is the University of Toronto in some ways is unthinkable without Frank Iacobucci, and we can say that here at the faculty. He is a former professor and a former dean of the Faculty of Law, but that is also true for the university level. As many of you will know, he was vice president and provost of the university from 1983 to 1985, at which time he was appointed Deputy Minister of Justice and Deputy Attorney General of Canada. And as all the lawyers in the room will no doubt know, he was appointed Chief Justice of the Federal Court of Canada in 1988, and then served as Justice on the Supreme Court of Canada from 1991 to 2004. And there is so much more. And he has remained active and contributes in so many different ways, and that I would love to be able to recite, but I will leave it at that because you're not here to hear from me, not even hear me talk about Frank Iacobucci. You're here to hear from Frank Iacobucci, and we are absolutely thrilled that he will be our inaugural John A. Tory Lecturer. So Frank, please, we are looking forward to it.
Oh, mhm. Thank you. Well, Dean Christopherson, Dean Brunet, thank you for that warm introduction. And I don't like the idea that you're not going to be in that deanship role. I don't know if there's any cause and effect by coming to speak and you're leaving the deanship. But I can just say I mourn your departure. You've been a fabulous dean. A fabulous dean. And I know that because I've done the job and I've also left a trail that is summed up by every institution gets better after I leave. And that's a leading example is the law school. And it's great to see John H. Tory here. I'm greatly honored and privileged to be the inaugural chair, speaker of this wonderful, wonderful support that the Tories family has demonstrated to both the law school and Rotman. And that's so fitting because John's father was a remarkable, you said remarkable, outstanding business person as well as lawyer. And I'm at the Tories firm. Been there, this is my 20th year. And the imprint that the Tories brothers left is indelible. It will last and last. I thank Liz, your mother and family, for establishing at your father's law school scholarships and bursaries at both Rotman and the faculty of law. It's a special thanks to Jennifer and you for your particular support of this initiative. I did not graduate from the law school, and it took me close to 20 years, not the usual 3 years, to get out of it. Not long after arriving at the law school, I met John A. And over the years had some contact with him, especially, and I say this, especially because of, I discovered he attended Phillips Academy, an outstanding prep school in Andover, Massachusetts. And when I found that, I at a lunch that I had with him, I was eager to ask him, why did he attend Andover? And I learned that After he and his brother graduated from UTS at 16, and this was research, there was an article in the Globe and Mail that mentioned this, in an incredible school class, incredible school class, John Evans, Fraser Mustang, a galaxy of future Canadian All-Stars. His reply when I asked him why did he go, he said because his father thought that graduating, by the way, when they had grade 13, of course, at 16, they would be kind of too young to go to university. And so that was the reason. And your grandfather apparently went down to Andover and spoke to the headmaster about his sons. And the headmaster said, according to John, well, okay, they will let them in, but the Canadians don't seem to do too well at Andover. Now, of course, that was a challenge. And John said in modesty, they didn't need that incentive, but they did perform and they graduated in the top group of the class, which is not surprising. Their accomplishments were also academically outstanding as well as professionally outstanding. So that adds to my honor and privilege to be speaking tonight. My lecture topic is not a subject that is discussed nightly at Canadian dinner tables. I retired as a judge just as my lecture topic was arriving in the courts. There was no cause and effect in that, but because although I got a glimpse of what was coming, I didn't take much because of its novelty. Although the Australians were, I think, the creators of GAARs. In any event, it wasn't rocket science to predict that this was going to have a tremendous impact on not just the tax community, but the broader business community. So in order to discuss the topic, the new GAAR and its preamble, I need to comment by way of background on the origin and judicial treatment of the GAAR, which has led to the recent amendments reflected by the new GAAR. In short, my lecture will be divided, like Gaul for you classicists, into three main parts. Part one is an introduction that deals with the GAAR's beginning and a brief overview of the main features of the GAAR jurisprudence and central questions I wish to discuss. Part two deals with preambles, starting with statutory interpretation of the Income Tax Act in the light of GAAR and the use of preambles in general, as well expressed in the new GAAR preamble. And then I end with part three with some observations. So I begin by summarizing the GAAR and its recent amendments. In doing so, I note that the GAAR rules are highly intricate, and Parliament and the courts have spent decades refining them. As such, I've limited my remarks to providing a high-level overview of the relevant principles. So what is the GAAR and why, when and why was it passed? Well, as you most know, the GAAR refers to the General Anti-Avoidance Rule in Section 245 of the Income Tax Act. At a high level, the GAAR is a provision of the Tax Act that states that even if, this is probably the fundamental premise, even if a taxpayer is entitled to certain tax treatment according to the letter of the law, the minister may impose a different tax treatment if there has been a misuse or abuse of the spirit of the law. That's a very much a generalization as a summary. The GAAR was enacted in 1988 with what I will call the old GAAR. The reasons for the enactment was ending what was described by the Supreme Court of Canada in Stuber Investments as the cat and mouse game of action and reaction, endlessly produced by complex, specific tax measures aimed at sophisticated business practices and the inevitable Okay, would you like some water?
Thanks.
Okay. All right. They aimed at sophisticated business practice and the inevitable professionally guided and equally specialized taxpayer reaction. The GAAR is a provision of last resort, meaning if a court is performing a GAAR analysis, the impugned transactions necessarily comply with other provisions of the Act properly interpreted and applied. This is, as we'll see, and many of you know, this is quite different as a provision of, especially of an income tax act. Now, there's a slide. I have two slides that show the three requirements to be met for the old GAAR. I mentioned that to apply to a transaction. They're up on the screen. They're really straightforward. The taxpayer must receive a tax benefit as a result of a transaction or series. The transaction or series must not have been undertaken or arranged primarily for a bona fide non-tax purpose. That's going to be changed. The transaction or series must reasonably be considered to result in a misuse or abuse of the relevant tax rules. So that's the three requirements. Now, the taxpayer bears the burden of paragraphs A and B, or 1 and 2, I should say. That is a burden that the taxpayer has to deal with. The third one is what the minister has to deal with. The minister has the burden of showing the abuse or misuse of the relevant tax rules. The taxpayer, it's clear that the third requirement is where the controversy really is and settles. That's the most contentious, but the minister often disagreeing on whether the relevant tax rules have been misused or abused. And there's a two-step analysis that's been developed by the Supreme Court in the Canada-Tosco decision that is used to determine whether a misuse or abuse has occurred. First is to determine the object, spirit, or purpose dealt with in the acronym OSP or OSP, or I prefer the word rationale. First, to determine the rationale of relevant provisions. And second, one must determine if the impugned transaction has defeated or frustrated that rationale or OSP. I can use them interchangeably. I've done a very brief summary in my paper on the different cases. I'm not sure with the time, but very brief for my purposes. In any event, Canada-Tosco, which is the first case by the Supreme Court, and a very important principle that was established is that the OSP analysis must be grounded in the text, context, and purpose of the provisions the taxpayer had allegedly misused or abused. Only the text, context, and purpose can inform that rationale, not tax policy concerns. In the court's view, it is this grounding in the legislation that differentiates the interpretive role of the court from the policy-making role of the legislature. In Lipson in Canada, the next case that I have, it importantly added the GAAR does not displace the Duke of Westminster principle that taxpayers are entitled to arrange their affairs to minimize the amount of tax payable. But the courts should not be reluctant, they went on, to apply the GAAR solely because doing so creates uncertainty. Then Copperthorne Holdings confirmed that the GAAR analysis is not a moral exercise and should be not conflated with a value judgment of what is right or wrong, nor with normative theories about what tax law ought to be or ought to do. In Canada, against Alter Energy, Luxembourg, held that the GAAR cannot be used to deny tax benefits that based on contextual purposive analysis. Parliament has made no attempt to deny that by enacting the GAAR. In other words, the GAAR applies only where Parliament tries but fails to deny certain tax benefits. It is a tool that can be used to fill in the gaps, as they say. The GAAR does not apply where Parliament makes no effort to deny a tax benefit, but the minister later considers that benefit to be undesirable, consistent with the previous cases. GAAR is not a tool that allows courts to implement new tax policy or to achieve more results. In the important most recent case of Dean's Night in Canada, that decision held that although the GAAR analysis involves a consideration of the provision's text, context, and purpose, the use of these elements differs from traditional statutory interpretation. The use to which the text, context, purpose are put refers to what these elements are used to interpret. In statutory interpretation, text, this is the important point. In statutory interpretation, text, context, and purpose are used to interpret what Parliament intended for a certain word to mean. It's the meaning of those three that is the result of that three-pronged text, context, and purpose. In the GAAR analysis, they are used to interpret the rationale or the OSP of the relevant provisions as a whole. In other words, as I said, their rationale or why Parliament adopted them. Now, there have been recent amendments to the GAAR, and the new preamble was introduced by those. The GAAR was amended on June 20th, 2024. The old GAAR continues to apply to transactions occurring before January 1st, 2024. The new GAAR generally applies to transactions occurring on or after January 1, 2024. The new GAAR has, as I said, a preamble, which I will be discussing. It also introduced several changes intended to make it easier for the Crown to apply the GAAR to prevent tax avoidance. For example, the new GAAR makes it easier for the Crown to establish a transaction which tax motivate. For the old GAAR to apply, the transaction or series must not have been undertaken or arranged primarily for a bona fide non-tax purpose. The new GAAR lowers this standard and now applies to any transaction where one of the main purposes is obtaining a tax benefit, as opposed to the tax benefit being the primary purpose. That really gives a big boost to the Crown. The new GAAR also introduces a rule that where a transaction is significantly lacking in economic substance, this tends to indicate a misuse or abuse has occurred. Now, it's unclear how this economic substance rule will be interpreted by the courts. But at the very least, and perhaps being a bit cynical, it would appear to put a thumb on the scale in favor of the Crown, where a transaction has no non-tax purpose. One can say right at the outset, why was a preamble used? I haven't put much of that in my lecture. Again, one would say, was it to get more weapons you have for attacking tax avoidance? I leave it to each of you to decide that. I will be saying something about the effect of the preamble, but the question of why was it put in is unusual. It's not unusual for statutes, as I will demonstrate, but it's unusual for a specific section. So my remarks today involve two questions. First, the Supreme Court's recent decision in Dean's Night raises an interesting statutory interpretation question. Where reasonably possible, should a court interpret a legislative provision in a way that is GAAR compliant? That is to say, as excluding abusive conduct, or should the GAAR purpose of preventing abuse influence only the application of the GAAR itself? In other words, are we having a new rule of statutory interpretation from the GAAR provision that it would apply to other provisions of the Income Tax Act? Second, the new GAAR preamble is repetitive, and there's no doubt in my mind of this, and affirmatory. That is, it adds no new principles to the GAAR analysis. The Supreme Court's recent decision, however, in a reference reenact respecting First Nations, Inuit, Métis children, youth and families, an Indigenous and constitutional law case provides a framework for interpreting affirmatory preambles. And so the question arises, how will the new GAAR preamble be interpreted in the light of this framework? And if you say, why would a case by the Supreme Court on Indigenous peoples have anything to do with tax? Well, it's the framework of a preamble. And one thing that the Supreme Court likes to do is promote its own work. And it does so by citing its work and looking for analogies. And I don't criticize that in any way. I think that's what most high courts do. And so that when I cite that Indigenous case, it may well have a framework of approach that would be applicable to the new preamble. Now I want to get to preambles, the second part of my remarks. But before commenting on the interpretation of preambles, I have to talk a little bit about statutory interpretation in income tax. Because the Supreme Court most recent commentary on such statutory interpretation in the income tax context, I think is Canada against Loblaw Financial Holdings. I find the case instructive in any event. An issue in Loblaw Financial was the interpretation of a provision of the foreign accrual property income, or the so-called FAPI regime. Tax practitioners, I think it's fair to say, generally consider the FAPI regime to be one of the most complex and detailed regimes in the Income Tax Act. In Loblaw Financial, the Supreme Court reaffirmed the textual, contextual, and purposive approach to statutory interpretation in tax matters, but added where Parliament has chosen to draft a set of provisions in great detail, a greater weight must be placed on the text of the provisions than on context and purpose, because, quote, if taxpayers are to act with any degree of certainty under such a highly detailed and precise regime, then full effect should be given to Parliament's precise and unequivocal words. End of quote. Now, unlike the FAPI regime, the GAAR regime is drafted in more general, less detailed terms. This is not to say that the GAAR is not a complex provision. It undoubtedly is. Only that the GAAR is drafted with a high level of generality, use, misuse, these kinds. Accordingly, applying the principle from law financial that emphasize text, wording, the purpose of the GAAR is likely to play a greater role in its interpretation because of the more general language in the GAAR as a matter of statutory interpretation. An interesting question regarding the relationship between statutory interpretation of the GAAR arises from the decision in Dean's Knight. At issue in that case was whether the taxpayer had abused subsection 111(5) of the Tax Act. In general terms, that subsection is an anti-loss trading provision that prevents the purchaser of a corporation from using the corporation's tax losses if the purchaser acquires control of the corporation, and after that acquisition of control, the corporation no longer carries on its pre-acquisition business. The purpose of the rule is to prohibit the transfer of losses between taxpayers. At issue in Dean's Knight was whether the purchaser had acquired control. Now, the term control was interpreted by the Supreme Court in a case Duhau Printers as referring to what is called de jure control, or the legal right to elect the majority of the board of directors. In Dean's Knight, the purchaser didn't have de jure control over the corporations whose losses it sought to use, and therefore the parties agreed that the disqualification of losses under subsection 111(5) did not apply. Consequently, this is an example of, as the last resort, the minister sought to deny the use of the tax losses by applying the GAAR of the relevant provisions as a whole. Because the two exercises interpret two different things: meaning and rationale, or OSP. It is not inconsistent to conclude that the meaning of control is de jure control, whereas the rationale of the provisions is to deny the use of losses where there's been an acquisition through de jure control or some other means. It is, of course, was open to the Supreme Court to conclude that the OSP aligned perfectly with the meaning of control. That is, the rationale of the OSP was to deny the use of losses where de jure control was achieved. But there is nothing inconsistent, in my view, or unprincipled in holding that the meaning of a provision differs from its rationale. Second, it is a principle of charter jurisprudence, again, say, why you go to charter? You've got enough problems with the Tax Act. You know, but it's, again, analogies, as we all know, are important in reasoning. And anyway, it is a principle of charter that where there are two readings of a provision are equally permissible, the interpretation that accords with the charter values should be adopted. It may be analogously argued that where two readings of a provision of the Income Tax Act are equally plausible, the interpretation which does not require the court to resort to GAAR should be preferred. In my view, this argument should be rejected. To add to this, I wish to rely with your indulgence. I wrote on an article I wrote some time ago in support of the following point. In the charter context, I agree that if a statutory provision is ambiguous, the interpretation which best accords with charter values is generally preferable. But I caution that charter values can't be used to alter the meaning of legislation absent argument by the parties on the issue. For if a statutory provision is found to infringe the charter, the state must have the opportunity to justify the infringement under Section 1 of the charter. Similarly, in the income tax context, I believe preambular expressions or I believe courts should not import a general anti-avoidance analysis into an ordinary statutory interpretation exercise. There are, of course, provisions in the Income Tax Act which explicitly incorporate an avoidance test of some kind. However, most of the provisions do not. In those situations, there are no words signifying a general legislative intent that the provision should not apply in so-called abusive situations. On the contrary, Parliament has expressed such a general intention throughout the enactment of the GAAR. That's where that kind of reasoning should be used for the general, and that means the minister has to raise the GAAR under 245. It can't be used by a method of get the same effect as a statutory interpretation would achieve. And that is really important because the minister has the onus of, as I mentioned earlier, of showing the misuse or abuse. Or a general legislative purpose or general anti-avoidance should not be applied to specific provisions of the Act. In my view, the Supreme Court was right not to revisit the interpretation of the term control in Dean's Night, because if it had done otherwise, it would have given the GAAR an exaggerated effect and upended a long-established and heavily relied upon principle of tax jurisprudence. Now I'll turn to a discussion of preambles in general. And I just want to digress a little bit to say that this point triggered in my mind very much an important aspect of our legal framework. And that is Canada has several important examples of what are important guidelines similar to preambles, both in our constitutional context and constitutional jurisprudence. Consider the 1867 Constitution Act, a reference to the desire to have a constitution similar in principle to that of the United Kingdom, and for Parliament to make laws for the peace, order, and good government of Canada in Section 91. And on our jurisprudence, the Quebec secession reference, the Supreme Court articulated animating principle of the Constitution to answer the reference questions on the unilateral secession of Quebec, as there was no express provision in our Constitution on secession. I mentioned these examples to show that even in the constitutional text, preambular type expressions or inferences from text have been used with important results and extensive jurisprudence concerning many subjects. Adding to this approach, some statutes contain statements of legislative purpose. These statements are sometimes contained in specific provisions, as in the ill-fated National Securities Act, or in a preamble in the Anti-Terrorism Act. This recital articulates the purpose of the legislation and the intention of Parliament that the purpose is to be pursued while respecting charter values. The reference to the charter is, of course, not determinative, but that the provision of the legislation accords with the charter principles. But the statement of purpose in the legislation, albeit in the preamble, constitutes legislative direction to interpret the legislation in light of broader statements of purpose. Now, I've dealt with some of these cases, the terrorism case, where the court, contrary to the arguments made by the Crown, wanted to give a very wide a very wide interpretation to the preamble. And the Supreme Court held that this characterization went too far and would have implications to outstrip the legislative intent. And courts, this is important caution, courts must not fall prey to the rhetorical urgency of perceived emergency or an altered security paradigm. And so the court concluded, basically, instead of all these tremendous purposes, the purpose of the act, the court was limited to the prosecution and prevention of terrorism offenses. Well, there's other cases that have gone on. I'm not going to go on to illustrate the similar principles. The one I do want to make more added comment on is the First Nations Inuit Métis children case, because this I think is particularly instructive for the preamble in the new GAAR. This was, as both the Supreme Court and the Quebec Court of Appeal noted, the Indigenous Families Act preamble and statement of purpose affirmed Indigenous peoples' right to self-governance, stating in the preamble, Parliament affirms the right to self-determination of Indigenous peoples, including the inherent right of self-government, and a statement of purpose that the purpose of this act is to affirm the inherent right of self-government. The Court of Appeal commented on the affirmatory nature of the preamble statement of purpose, noting it was unusual, as when drafting laws, legislatures naturally act on the basis of their belief in what the Constitution allows them to do. But express legislative affirmation of the meaning or scope of a constitutional provision is out of the ordinary. So in its reasons, the Supreme Court addressed this comment and cited with approval an article written by Professor Kent Roach of this law school. He did a wonderful article on the uses and audiences of preamble in legislation. I'm sure tax lawyers will have to get quite familiar with that article, not for reasons that Kent had in mind when he wrote the article, namely in a tax world. The affirmation and what Professor Roach's comments are basically saying that preambles are dialogical. Parliament is using an act to communicate to courts and to society. And it's positioned that the law must recognize the importance in that case of Indigenous self-government in relation to child and family services. So the unusual right use of affirmations of rights can be explained in almost a Parliament trying to persuade people and society to support the initiative of self-government and self-determination for Indigenous people. So Parliament is not acting in vain. It is that dialogical purpose that's being expressed. So the new GAAR preamble now, which I'm going to discuss, first, I will say that it is affirmatory of existing principles. And I then turn to the implications of the affirmative nature of the preamble. And the text of the new preamble, if adds few, if any, new principles to the GAAR analysis. And I'm going to put up now. I'm not going to go through all this. You're going to have to trust me when I say that the sources of the components of the preamble are existing cases that have been decided and statutory provisions. With no novelty, for the most, in my view, by what is put in the preamble. It is affirmatory. The Supreme Court in framework is in the indigenous case may be adopted by tax courts, and just considering the preamble. It could be, it's dialogical. It's hard to think of the Tax Act having a conversation with citizens of our country, but it could well be in sending a message that this is a section of the Income Tax Act that most people don't have to worry about, because it's really aimed at tax avoidance by usually a sophisticated audience. So now to get to some concluding observations. To begin with, I caution that courts should keep in mind the principle from the terrorism reference that courts must not fall prey to the rhetorical urgency of a perceived emergency or an altered paradigm in interpreting the new GAAR preamble. Arguments that the GAAR analysis should be completely reworked because the new GAAR and its preamble were introduced in response to a tax avoidance emergency should be rejected. As stated in the terrorism reference, we must not lose sight of the particular aims of the legislation. Where Parliament has not legislated that the GAAR analysis be changed, the court should be reluctant to depart from established principles solely on the rhetorical basis that the GAAR has been amended to crack down on tax avoidance. I would also note that in conjunction with Parliament's release of the new GAAR legislation, the Department of Finance released technical notes commenting on how the new GAAR, including the preamble, ought to be applied. These technical notes should, I think, in my view, should be used sparingly, as they are mere commentary and do not form part of the law. And as Chief Justice McLaughlin stated for the court in the Shell case, the court's role is to interpret and apply the Income Tax Act as it was adopted by Parliament. In legislation as detailed as the Income Tax Act, it is evident that Parliament selects the words with which it conveys its intentions very carefully. To alter the clear meaning of such words through an examination of purpose derived not from the words themselves, but from technical notes is clearly unacceptable. Parliament speaks through legislation. Any contradictory or qualifying statements of object or purpose expressed other than through the legislative text must be dealt with cautiously. Then I covered it as another, the balancing exercise that has been commented upon, and the Duke of Westminster principle in the GAAR analysis. Now, paragraph 245.1b states that the GAAR strikes a balance between the government's responsibility to protect the tax base and the fairness of the tax system and taxpayers' need for certainty in planning their affairs. This provision may be used to make an argument along the following lines. The GAAR involves a balance of interests. The interests to be balanced are limited to those specified in that one paragraph. Only a taxpayer's need for certainty, not their right to arrange their affairs to minimize the amount of tax payable, i.e. the Duke of Westminster principle, is considered in the balance. Accordingly, the Duke of Westminster principle is not to be considered in the new GAAR analysis, though the principle could still be considered outside the GAAR context. I think this argument seems unlikely to succeed. As the Supreme Court held in Alta Energy that the Duke of Westminster principle is derived from the rule of law and has been deemed the foundation stone of Canadian law on tax avoidance. It seems likely that the courts would require a clear statement from Parliament, or at least a clearer statement, in the absence of the Duke of Westminster principle in the preamble to remove such an important principle from the GAAR analysis. That said, the courts have held that the Duke of Westminster as attenuated by the GAAR. And that was in Dean's Knight. In that it does not permit taxpayers to raise their fares in a manner that operates to abuse the rules of the tax system. I find the comment interesting because the Duke of Westminster principle is most accurately stated as saying taxpayers are entitled to raise their fares in accordance with the law to minimize the amount of tax payable. In other words, the Duke of Westminster principle has never meant taxpayers could violate tax law to minimize their tax payable. And because the GAAR is part of tax law, it arguably does not attenuate the Duke of Westminster principle, but it simply increases the number of laws that the taxpayer must comply with before successfully implementing a tax plan. So this is much like how a legislative amendment to restrict certain behavior would not be said to attenuate the Duke of Westminster principle, but simply to restrict the scope of permissible tax planning. If the courts are of the view that the GAAR truly accentuates the Duke of Westminster principle, as opposed to simply limiting what constitutes legal tax planning, they may be more open to finding that the Duke's principle is not to be considered in the GAAR analysis. Well, in my view, it may be possible for Parliament to have its cake and eat it too. That is, to minimize the influence of the Duke of Westminster principle in the GAAR analysis, while not attenuating or limiting the principle and raising difficult questions regarding the rule of law. As I've discussed, the statutory interpretation analysis and the rationale analysis analyze two different things: the meaning of a provision and the OSP of the provision, respectively. As such, it would theoretically be possible for a court to find a legislative provision properly interpreted has not limited a taxpayer's right to plan their affairs, while simultaneously finding that the OSP of the provision was to limit a taxpayer's ability to plan their affairs. That, I think, was a similar finding that was made in Dean's Knight, where a provision properly interpreted denied losses only in cases of de jure control, whereas the OSP of that provision was to deny losses where something broader than de jure control was achieved. On another point, on fairness of the tax system and the consideration of tax policy. On another point, it could be argued that the principle of the fairness of the tax system in the new GAAR preamble justifies a departure from existing jurisprudence, that the GAAR analysis does not involve a search for that the GAAR analysis does not involve a search for an overriding policy of the Tax Act, and that the GAAR analysis is not a moral exercise concerned with right and wrong. It may be argued that ensuring fairness of the tax system requires the courts to focus on policy and notions of right and wrong. Well, there are two reasons why this argument is likely to be and should not be accepted. First, the preamble states it is the government of Canada, the executive branch, not the judicial branch, that is responsible for protecting the fairness of the tax system. Parliament is accordingly not assigned the courts its responsibility. And second, as stated in Canada Tusco, formulation of tax policy and moral judgment about what is considered right and wrong in the tax system is the role of Parliament. While the courts are experts in the interpretation of the policy Parliament implements through legislation, they are unaccustomed, quote, and not equipped, quote, to formulate tax policy itself. Now I'm going to say a few words on the sanctions, fines for those found to have abused or misused provisions of the Tax Act. This bothers me a little bit. The new GAAR introduces a penalty of 25% where GAAR applies to a transaction and the taxpayer did not report that transaction to the minister. I find it a little questionable the resort to sanctions, even though this is beyond the scope of my paper. Got nothing to do with the preamble. And I said judges should not get involved in what is policy. But I'm an ex-judge. And for the last 20 years, I have acquired freedom of expression. So I can say, it seems to me the new GAAR rule is a restriction on tax planning and not a revocation of the Westminster principle. So I raised just the question, why is there a need for a sanction, except presumably as a form of deterrence to those who wish to exercise their rights to advance some tax planning they believe to be non-abusive? But I ask, is that a justification? Well, I end by citing something I heard a convocation speaker once said after his address. And he said something that I'm going to say about what I just discussed. Namely, you may think what I have said is pure nonsense, but I would suggest to you it isn't that. It's applied nonsense. Thank you for your very courteous silence.
Right. So thank you very much for those remarks, Frank. Totally fascinating and engrossing. As somebody who's been thinking about the GAAR for my entire academic career, something that I think you didn't have the luxury of doing. So like, think about Frank's timing here. It's pretty impeccable. Joined the faculty, taught here for many years, left immediately before Stubart Investments was decided by the Supreme Court in 1984. You were already in Ottawa in 1984. And Stubart Investments was the case where the Supreme Court was invited to adopt a judicial anti-avoidance test, the business purpose test, economic substance doctrine, and declined to do that, which then prompted a study. What do we do about the, this judicial resistance to adopting a judicial anti-avoidance principle along those lines? And the result was the GAAR. And so the GAAR, for those of you who were around in the 80s and paying attention to these things, I wasn't, I was in grade school, was introduced. It took effect September 12th, 1988. And again, look at Frank's timing, totally amazing, because then he's appointed to the federal court, and then he lands on the Supreme Court. And you think, okay, so the GAAR is in effect in 1988. You give it some time to work its way through the system. The minister's got to like find some cases, challenge some cases that end up in the tax court and then the federal court of appeal. Eventually, they'll make their way, one would think, to Frank and his colleagues on the Supreme Court. It's not like Frank was a flash in the pan at the Supreme Court. He was there from 1991 to 2004, so 13 years. And he started 2.5 years after the GAAR was implemented. So we're giving it 15 years for a GAAR case to make its way to Frank's chambers at the Supreme Court, and it doesn't make it. And I know there were, I believe, 26 Supreme Court of Canada tax judgments issued while Frank was on the court. And I believe he participated in every single one of those judgments. The only judge who sat on every tax appeal while they were on the court, I believe. And he left, and no sooner does Frank leave to come back and take the helm of this university as interim president, lo and behold, Canada Trust Co. arrives at the court, and it's heard. So I've been spending the last 2 decades wondering about what Frank thinks about the GAAR. And tonight, I finally got the opportunity to hear a little bit about what Frank thought about the GAAR. And so thank you for that wonderful opportunity. I do have one question or one observation, and then I think then we'll take one from the audience, and then we're going to wrap up, and we can all make our way out and enjoy some refreshments and stuff. The question is this: I was looking back at some earlier materials, and at the time the GAAR was introduced, Michael Wilson, who was then the Minister of Finance, outlined the purpose of the new GAAR as follows. He said, and I'm quoting here, "New Section 245 of the Act," that's the GAAR, "is a General Anti-Avoidance Rule, which is intended to prevent abusive tax avoidance transactions or arrangements, but at the same time is not intended to interfere with legitimate commercial and family transactions. Consequently, the new rule seeks to distinguish between legitimate tax planning and abusive tax avoidance, and to establish a reasonable balance between the protection of the tax base and the need for certainty for taxpayers in planning their affairs." And this sounds an awful lot like the preamble to the GAAR that we see in the new GAAR. So to your point, there's not much new there. This is going back to before the enactment of the original GAAR. But I guess one difference, and you talked about this in your remarks, is now it's in the statute. It's not just ministerial say so anymore. Now it's in the statute. And so Parliament has endorsed and embraced that language. But then this makes me think, well, is it really the GAAR that needs a preamble? Isn't it all the other parts of the Income Tax Act that might benefit from preambles? Because if we're looking for the object, spirit, and purpose of the various parts of the act to determine whether or not there's been a misuse or abuse of those parts of the act, might we not actually say this whole preamble in the GAAR is a little bit misplaced? Shouldn't we be looking for preambles elsewhere in the act to guide the courts in figuring out what is the object, spirit, and purpose of the other parts of the statute? And so maybe I'll put that, that's my question. It was a long question, but there are lots of different ways you can take it. Oh, yeah, you're still, you got your comments.
Is it on? Can you hear me? I don't know. Well, I think it's an excellent question. I don't know preambles for sections. I mean, you can see the Constitution has a Section 91, the preamble, peace, order, and good government, if you want to call that, but it's not the preamble as we know it. By the way, I should have mentioned this again in Kent Roach's article. Preambles are modern in great use in Canada, a lot. Going from few statutes to tens of statutes now. But they go back, get this, to Plato. Plato was an enthusiast for preamble. And I haven't thought much in my life about Plato, and I wouldn't have thought he would have thought about preambles. But he was very, I mean, talk about ahead of his time. It is quite amazing. I actually think that the components that the minister should apply equally to the whole act. They're responsible for the arrangement of all things, not the courts. The courts can deal with fairness, of the tax system. They can deal, I mean, the text, context, and spirit, it's all of those kinds of things are supplied by the legislation they choose to enact. So it is in the context of business dealings that the courts don't have anything to deal with that. So it is an interesting question, and it's probably, one can be left with this inference. I think putting it in the GAAR maybe I said this to one of my colleagues at Tory, who did tremendous help in the preparation of the research and beyond. I said that maybe this was a signal by putting it in a preamble to the GAAR of the insistence and maintenance of vigilance of the taxing authorities to monitor very closely tax avoidance arrangements. That it's more emphatic as just as it is affirmatory in its resolve to not make war with tax avoidance, but to be more vigilant in scrutinizing tax avoidance arrangements.
Great. Maybe we will take one question from the floor. If anyone has a question. Professor Weinram? I think there may be a mic here.
Thanks. Is this on?
Do I have to use it? Yes. Yes, no, you have to use it.
Frank, put yourself back, put yourself in 1923 and pretend you're still Deputy Minister of Justice. And the preamble comes across your desk and you're asked whether the preamble should be put in and what its effect will be. What would you have said?
In the Income Tax Act?
Well, if you were Deputy Minister in 23, when it was all introduced.
Well, what year, 1923?
I think he meant 2023. It's not as far back as Plato.
I mean, yeah, that's what I knew that when I said Plato, someone said, well, you weren't around then, but I would look at the act. Why, I have to ask my colleague, why do we want to put it? What's the intention? What purpose is it going to serve? I think it's useful to help direct the court to the question of constitutionality, the question of charter compliance in particular. But so I don't know what it would depend on what I saw was the purpose. I do think in something like self-government, I would definitely put in that. We're talking about trying to improve. To me, the number one societal issue in this country is improving the relationship with our Indigenous people. And I would be using that as an aid to goal of improving conversation, not only with the courts, but with the greater society, as Roach says in his article. So if there's a social utility side to it, yes, I would put in.
Super, thanks. I'd like to invite Dean Christopherson to come up now and say a few closing remarks.
Well, thank you very much. So I'm from the business school, and so probably not an expert on preamble, but I found it very insightful. In my prior career doing a lot of research, I actually did research at the intersection of finance and tax. And as I was sitting there listening, I kept thinking, oh, this is great. It's an exogenous shock and we can test. But then when you told me that it took 13 years before this came through, I'm like, well, there's no degrees of freedom. There's no way for me to test this. But anyways, really fascinating and very enjoyable. So as we conclude this, I would really like to thank all of you for coming, for your presence, for being part of this inaugural lecture. Echoing Juta's sentiments, this evening was really made possible by the Tory family and their generosity and commitment to the JD-MBA. It's a long-standing partnership for which we are incredibly proud. And it's really something that I think has grown and really grown in reputation over the years. And we really want to continue to see that excellence continue. To our distinguished speaker, Professor, Dean Emeritus, Justice, the Honourable Frank Iacobucci, thank you for being here. Thank you for sharing your expertise, your thoughtful analysis on the new preamble to the General Anti-Avoidance Rule. Your exploration of its significance as tax law and its implications for statutory interpretation and jurisprudence has been both enlightening and thoughtful and thought-provoking. So thank you so much. And of course, Professor Benjamin Alarie, who helped brought forward many different questions. Thank you so much for being here. And it was really an honor to have you both here for the inaugural lecture. So on behalf of the Rotman School and the Faculty of Law, I really want to thank everyone. And we really look forward to welcoming you back to future events. So thanks so much.
I started taking.